We thank you so much for watching Law School Made Easy at Law School Made Easy 256. We ask you to subscribe, to share, and keep liking our videos and keep the comments coming through. Today we want to discuss Land Law 1, and we want to discuss priorities of legal and equitable interests. These are what we call the competing interests. A very similar question would be, have you been wherever you stay in your villages? Have you heard of people complaining about land? People arguing when dispute arise that is my land, that is my land. I was the first to buy. I have a title. I have an argument. I have this. In this video, we are trying to ascertain when you are faced with those competing interests. When two people come to you, they both have land titles, okay? They both have land titles to the suit land. How do you determine it? Who will take the day? Who wins over those? Those are what we call the competing interests. If two people come to you as a lawyer and they're asking you, they're saying they both have agreements to sell, the purchase agreement, they both have purchase agreement, and they are before you. They are asking you, who is the owner of this land? I have a purchase agreement, and this person also has a purchase agreement. What happens if you're a lawyer and someone comes to you and tells you, I have a land title, and then somebody tells you, I also have a purchase agreement? What happens? How do you decide? If someone comes first and tells you, I have a purchase agreement to that suit land, and the other one comes later and says, I also have a certificate of title to that land. So how do you go about these priorities? How do you decide these competing interests? This is the video for you. That is going to decide, to let you know how you go about this. The issue of our competing priorities at common law was that where we have two priorities, okay, the first in place takes the day. The first to prevail will always take the day. When we have two competing priorities, the first to take place will always prevail. Look at section 48 of the RTA. So let's enter into these priorities. But note, the first in place prevails only works where the priorities are legal and where they are equitable. Okay? But let's now go into all these priorities. Number one, we have competing legal interests. When we say competing legal interests, here we mean that, take an example. If two people come to you, they both have certificate of title, they are both claiming that this land is ours. That is what we call competing legal interest. Both these people, their interest in land has been registered and they all have certificate of title. How are you able to determine this? The first to be registered will prevail. Look at section 48 of the RTA. Where you are faced with competing interests, competing legal interests, the first in place will always prevail. The first to be registered will always prevail. I'll give an example. If I buy land on Monday and then a colleague buys land on Thursday, the same land, we buy from the owner. I buy on Monday and then my other colleague buys on Thursday. If the colleague who bought on Thursday goes and registers and gets a certificate of title, I also go later, I get a certificate of title. Even when it was me who bought first on Monday, the first person to get a certificate of title, that one will prevail, is one that takes precedent when it comes to land matters. Okay? Then, let's cross to competing equitable interest, where we have, remember we said, equitable interest means land, interest in land that has not been registered. Both of you have come before me, and you are both presenting purchase agreements. There is the one which came first and the one that bought later. So if I buy on Monday and you buy on Thursday, okay? If I buy on Monday and you buy on Thursday, okay? That means that the one who bought on Monday takes precedent, because interest in land has been registered, but it is not yet registered. Secondly, if the second equitable interest, the person buys that land with the notice that there is an equitable interest already registered on that particular land, then the equitable interest registered first will prevail. That's the rule. The one that comes first will always take precedent when it comes to equitable interest. So we have discussed the competing legal interest, and we are saying the first in the place takes precedent, and we have also discussed the competing equitable interest. Okay? Now, we go to what we call the competing legal and the later equitable. We have first a competing legal, and later on the same land, we get an equitable interest. That we have someone with a title to the land, but later on the same land, there is someone else who has bought, who has a purchase agreement. So we're saying competing legal and later equitable interest. The general rule to that is that the holder of the earlier legal interest will have the priority. The holder of the earlier interest will have the priority. Where we have a competing legal and later equitable interest, the earlier legal interest will take priority. This person has a certificate of title. In our subsequent videos next semester for year 2, second semester, we shall be discussing the divisibility of a title. That this person has a title. And section 59 of the RTA poses it that certificate shall be conclusive evidence. So where we have an earlier legal interest vis-a-vis the later equitable interest, the earlier legal interest will take place. Listen, unless the competing legal interest, there has been signs of fraud, that is when the later interest will succeed. I repeat, where we have competing legal and later equitable interest, we are saying that unless there have been incidents of fraud cited, but the earlier legal interest will take place. But where you have instance of fraud cited, then the later equitable interest shall take precedent. Hope I am clear on that one. Then the last one is let me check it out. Competing prior equitable and later legal interest. We have competing prior equitable interest and later legal. So we have an equitable interest, let's say purchase agreement, and later we have a legal interest. The general rule is that the latter legal interest will prevail over the earlier equitable interest. Where we have earlier equitable interest and the later legal interest, the legal interest will prevail over the earlier equitable interest. For as long as the other legal interest was obtained for a valuable consideration and in good faith without notice of the earlier equitable interest. Okay? The land legislator put it and said that as long as the legal interest has been acquired for a valuable consideration in good faith without notice of the earlier interest, the purchaser of the legal interest bears the honors of proving that he has never acquired the land fraudulently. Okay? Where there is an earlier equitable interest and later legal interest, the later legal interest will take the day. For as long as it was acquired through a valuable consideration and in good faith without notice of the earlier interest, and the burden will lie on the person of the legal interest to prove that there was no fraud in acquiring that piece of land, and then that piece of land would have exchanged hands. So those are the priorities. So the moment you are faced with the challenges with the land law and people, you want to determine who is the owner of this land, we first have to run to what we call the priorities of both legal and equitable interest in land. Thank you so much. Until next time, subscribe, share, like our videos.